Welcome everyone to this Privacy Rules Privacy Espresso. My name is Alessandro Di Mattia. I'm Legal and Executive Officer at Privacy Rules. And today we are going to speak about a very recent news, that is the one related to the adequacy decision taken by the EU Commission in relation to the UK. And we are going to do that with our expert from the UK, that is Kim Walker, partner at Shakespeare Martineau. So Kim, thank you very much for being with us, first of all. And let's warm up by starting understanding what happened. So what are we talking about, and what is the adequacy decision about, and what's the history of this decision?
Okay, thank you, Alessandra, and hello, everybody. Yeah, well, very recently on the 28th of June, last Monday, the adequacy decision was finally adopted by the EU. And this, as I think you'll probably know, is essentially a declaration that UK data protection laws offer essentially equivalent protection to that afforded by EU laws. And it means that transfers of personal data from the EU to the UK can take place unrestricted without the need for further safeguards, such as the standard contractual clauses. There's already an adequacy decision in the other direction. So the UK has already granted the EU an adequacy decision, so that's not been a problem. But it's been a really long road, and we'd all hoped that the adequacy decision would have been completed and issued and adopted by the end of the Brexit transition period at the end of last year, but that didn't happen, didn't prove possible. So the trade and cooperation agreement signed between the UK and the EU just before Christmas last year included a bridging mechanism, which really gave the Commission another 6 months to try and get an adequacy decision in place. And you know, that was going to expire on the 30th of June. In other words, yesterday. So the adequacy decision has been granted at the 11th hour, as always seems to be the case. And you might ask, why on earth did it take so long? Because it's hugely important for not just UK business, but also businesses in the EU wanting to trade with the UK. And it's been estimated that the cost to UK business of no adequacy decision would have been about £1.6 billion, and that's just the cost of putting safeguards in place, the compliance costs, is completely disregarding all the costs of lost trade and disrupted data flows and so on. So yeah, it was, and obviously the scale of data involved is hugely important. I think I read that 11% of all global data flows through the UK at some point. And about 70% of UK data flows, UK businesses flow to the EU. So, yeah, really important.
And Kim, if I may ask on this in relation to that, what's the British government attitude also in relation to the GDPR now? What do you how do you think is going to move in relation to this different regulation now that you are, let's say, free of deciding how to move?
Well, I think one of the reasons it's taken so long is that the European Commission and the EU are very suspicious of the UK government's attitude to the GDPR. And the UK government has already said that it thinks the GDPR is bureaucratic and costly to business and blocks data flows potentially. And so I think there is they had a task force in place which has recently reported and said that they want to loosen the GDPR, make it less strict, less cumbersome, try and particularly enable the UK to grant adequacy decisions more easily and more quickly to other countries, so that the UK can deal more easily, and UK business can deal more easily with countries that don't have a GDPR-like regime.
Okay, that's very interesting, Kim. And in relation to that, I was wondering, do you think that exactly for this reason there is a kind of, let's say, Schrems challenge for the UK adequacy decision, meaning it may fall because of exchanges of data between the UK and other countries that are not adequate for the European Union?
I'm not a betting man, but if I was a betting man, I would be putting money on there being a challenge. And I'm sure Max Schrems is thinking very carefully about this as we speak. The situation really is not very different from the UK, and frankly the UK's surveillance laws, mass surveillance laws, which were the things that really caused the problems with the US's surveillance laws. The UK and the US's surveillance laws are really not that different. Brussels says and justifies the adequacy decision on the basis that the UK is subject to the European Court of Human Rights in Strasbourg, and therefore there's some form of sort of overall oversight over the way the UK's mass surveillance laws are operated. But actually the UK government anyway is keen to move away from the European Court of Human Rights anyway. So yeah, there's a good chance, I think, that Max Schrems or somebody similar will make a challenge on very similar basis to the challenge that was made to the Privacy Shield. I think it's particularly likely that there'll be a challenge, because I wouldn't be at all surprised if the UK and the US get some sort of deal in place, which will effectively be a backdoor for EU data to flow through the UK to the US without safeguards having to be put in place, and that is a potential weakness which the adequacy decision has identified.
No, that's really interesting, Kim. Thank you very much for sharing. Indeed, that's a risk that we should consider, definitely. And do you have any takeaways or advice that you would like to give to a company that now is in the UK on how to deal with this situation? Because it's pretty strange. It's a particular one. So what should they be doing? How careful they should be, and on what?
Well, for the first time, this adequacy decision has a sunset clause, so it lasts for 4 years. All the other adequacy decisions that have been granted have been perpetual. So whatever happens, this adequacy decision is going to be reviewed in 4 years' time, which again shows how suspicious I think the EU is of the way UK GDPR is going to develop and diverge potentially from EU GDPR. So I think UK businesses should grab the adequacy decision while they can. We have an adequacy decision, but there is every chance that it will be struck down within the next 4 years, or at least after 4 years. But in the meantime, I think it's a great relief. We don't have to worry about standard contractual clauses, the time-consuming, costly, bureaucratic process that involves, particularly with the need to do transfer impact assessments now. So UK businesses, I think, should proceed as like we did when we were part of the EU, frankly.
Yeah. Also because your data protection authority was pretty active and in order to be compliant with GDPR so far. So definitely right. So we end up of our time, Kim. So thank you very much for being with us and for this brief summary and explanation on what's happening on this adequacy decision. Thank you also to all the people following us today, live and in the recording version. So I would like to thank you all for being with us. And I say goodbye to all and see you next Thursday with the next Privacy Espresso. Thank you. Bye-bye.
Goodbye.